my name is Divyansh Dev, and this is my presentation for the second round of CPL Fellowship. The title of my presentation is How can the Indian Constitution and Judiciary System be used more effectively to combat corruption and increase accountability of public servant? This presentation has 5 parts. I'll now begin with the first part. The first part talks about decoding this particular question, which begins with how and focuses on effectively, which means that you are asking improvement mechanism in the current system. If I see the public servants which are executive needs to be kept in check and balances by the judiciary and the legislature by amending the Indian Constitution. I now move on to the second part, which is the root causes. So there are 3 root causes of corruption. Cause number 1, historical. Cause number 2, economical, and cause number 3, political. Now, what is the historical cause of corruption? Right from the times of Mughal and Sultanate period, we have the concept of bakshish being institutionalized, and this particular system or the concept got inherited by the East India Company, hence forming the history of the corruption. Economical reason. So, corruption gives you 2 incentives. What is the incentive number 1? That it reduces cost. Incentive number 2, that it provides you government benefits. What is the cause number 3? Political cause, wherein public servants who indulge in corruption are given systemized patronage by the political class. All these 3 being the root causes makes us move to the current standing of India vis-a-vis current corruption reporting mechanisms. Ladies and gentlemen, at this point you should understand that under the Indian Constitution, equality before law is a fundamental right, and wherein if we have a culture of corruption, wherein people with means buy justice, this means that we as a society do not possess equality before law. And this is also seen in some of the international reports that we have with us. In Amnesty International Global Perception Index 2016, India is ranked 79 out of 167 nations. In Global Frauds report, it has come that India has highest reportage of corruption cases worldwide with a figure of 73%. And now move on to my fourth part, which is current enforcement mechanisms. Ladies and gentlemen, we as a nation have great amount of enforcement mechanisms when it comes to corruption. We have Indian Penal Code Section 161, 162, 165. We have Prevention of Corruption Act. We have bodies such as CAM and Central Vigilance Commission. Then we have Competition Act and Companies Act in terms of regulatory provisions. We have Income Tax Act in terms of political funding and illegal gratification. We have Whistleblower Protection Act, and recent Demonetization and Benami Transaction Act 2016 was also aimed at curbing corruption. Now this has got certain pros and cons. What are the pros? Pros are these are all comprehensive enforcement mechanisms which are reform oriented and are also multidimensional. It also has certain cons that all these mechanisms have lax enforcement. These are complex mechanisms with great amount of loopholes which are not difficult to discover. Then these all enforcement mechanisms at some point of time comes across as a work in progress mode with great scope of improvement. Having this covered, I now come to the main part of my presentation, which is the solution vis-a-vis the problem. So I have offered many solutions. My first solution is a grievance redressal mechanism. Ladies and gentlemen, if a judicially activated grievance redressal mechanism should be there in place, wherein the citizens should be free to name officers if they are asking for bribe. The second solution that I have offered, ladies and gentlemen, we now have right to privacy as a fundamental right, which the judicial activism should also be extended to whistleblower who expose corruption of public servants. My third solution, ladies and gentlemen, is amending Article 311, which talks about all India services, wherein if you find a public servant who is indulging in private office of profit, he should be debarred from the service right away. Also, Article 311 should be amended to have no public servant being remote controlled by politician. Often it is seen that when a public servant is caught prima facie in a corruption case, the political class delays it in the form of permissions and approvals, thereby causing delay in justice. Second, ladies and gentlemen, it should be understood that the current government came with a motto, na khaunga na khane dunga, but the dismal reality is that the Lokpal has not been enforced till yet. What I would suggest is to enforce the Lokpal immediately and also give it a stature of a constitutional body like in the likes of Election Commission of India and Comptroller and Auditor General of India. Quit dam enforcement. Quit dam enforcement is, as a system, is followed in US and UK, wherein if I whistle-blow or expose a corruption nexus between a private body and a government, then I get certain share of profits that was enjoyed by the private firm. My next solution is aimed at United Nations Convention on Corruption, to which India is also a signatory. It has one brilliant provision which we do not find in any of the enforcement mechanisms. It is to have an aggrieved party seeking compensation or damages for the loss caused by corruption indulged by a public servant. So if a public servant indulges in corruption and if that causes a loss to me, then I should seek compensation for that. This is one of the provisions in UNAC. Then I talk of simplifying the legal codes. Often it is seen that a great amount of complex legal codes give extraordinary power to corrupt government officials who use this to extort money from businesses. My final suggestion would be right to services and public procurement bills. Ladies and gentlemen, in the recent Sabu Matthew George case, right to be informed is also a fundamental right under Article 19, which makes me suggest that right to services and public procurement bills should come under right to be informed, and therefore under Article 19, wherein I should know that why, despite funds and money being allocated to the services for the ordinary citizens, it's still not being followed or being given to me. This provision tries to constrain the arbitrary power of the government and gives more bargaining power to the ordinary citizens. On this note, I would like to end my presentation. I have summed up the presentation in terms of 5 parts. I decoded the question, I gave the root cause, I gave the current standing, I gave the enforcement mechanism, and I am ending with solutions. This was a pleasurable experience, and I am looking forward to the next set of communication from the CPL Fellowship. Thank you so much. This was Divyansh Dev.